Alex here with part 164 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0. If you haven't seen it yet, that's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed, cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We go into the judge's order denying the debtor's exam and awarding attorney fees. This entire thing is going to get overturned on appeal, so you don't have to really think of it as impacting me because it doesn't in the end anyway. It does take a lot of work for me to correct the judge's mistake, but it doesn't cost me any money, so that's at least, one of the plus things. I will say that there is quite a lot with regards to my mindset on this issue. I guess I'll start off with a comment from a viewer. I wish I could remember the viewer's name, but the viewer, he mentioned that the judge probably did what she did because of my ex's new attorney. And I have to strongly agree with that. In fact, I did talk about that, but not quite as directly in the way this viewer said it. This is something that I talk about in the video meta rulings. Sometimes the court isn't really thinking about what's right and wrong, what makes sense and what doesn't make sense, what's best for the kids. A lot of times the court is thinking, what do I need to do to look fair and balanced? And so this is one of the reasons as to why judges like this, mainly in the family division, will commit reversible error, because they're not really paying attention to the case. They're thinking, well, she paid for this lawyer. It probably cost her $5,000. So, I'm going to have to give this person something. I can't just let this lawyer do all this work and then lose. And this is, it sounds crazy to us, but this does happen. This is really a thing. I was representing myself for all these years, and I talk about not just this, but I also talk about best interests of the parents. I have another video titled Best Interests of the Parents, where the judge is so concerned about how a mom or a dad is going to feel that they end up inadvertently, at least I hope it's inadvertent, they end up inadvertently making a ruling that damages the child because they're not paying attention to the child. They feel bad about mom, or they think dad deserves this, and they're trying to look fair and balanced and equal. And so they need to blast this other parent who didn't do anything wrong just so that they look like they're equal. And then, of course, they don't really understand the dynamics between mental health issued parents, high conflict child custody, and without realizing it, these judges do these things that increasingly cause damage to not just the families, but to also the court system as well, and to their own reputation. At least, if you file an appeal and get them overturned, it'll at least do some damage to their reputation as well. So this particular situation, it's probably a mix of all these different things. And I think most people are going to say it doesn't make any sense because we just saw the hearing video. We just saw part 152 to 156 of the My Docket series. What is wrong with this judge? I talk about this problem as well in the video, The Judge Does Not Remember You. It is completely and totally normal, sad as it may be, for a judge to watch an entire trial with you and your ex, say a bunch of things on the bench, and then a few months later do something completely different. And the reason why is because they just don't remember you. This judge went on the bench and scolded my ex for not wanting to pay any of this money. And she said that I, bent over backwards, and that I took out loans, and that I got all this credit card debt. And so therefore I deserved all these thousands of dollars that my ex hadn't paid for over a year. And here, a couple of months later, now the judge is saying, you know what? You should pay her more money. Not only did she not pay multiple thousands of dollars for a surgery, but you're going to pay her another $1,700. So you're already super poor. You already didn't get child support for 13 months. You're owed $2,000 for all this medical damage. You took out loans, credit card debt. And you know what I'm going to do for you, sir? I'm going to make you pay another $1,700 to her attorney. Luckily, the Court of Appeals is not going to put up with that nonsense, and they're going to overturn her decision. They're going to say that she abused her discretion. She's going to get called out for all this nonsense. But from our perspective and from the Court of Appeals perspective, this judge looks like a crazy person. But in the judge's mind, she can't remember any of this stuff. She doesn't remember the hearing. She doesn't remember the trial. She doesn't remember that my ex owes multiple thousands of dollars. She completely forgot that I took out loans. All she knows is, here's this lawyer who got hired, and here's a letter, and he's trying to be reasonable, and so therefore, this guy should pay $1,700 to his ex. That's all this judge is thinking. And then she just signs it, and she moves on. She's not paying any attention. And so I filed this appeal, and of course, it works. Thankfully, the Court of Appeals pays attention to what's going on. And this whole entire mess is going to just snowball, because after the Court of Appeals reverses her decision, After the Court of Appeals enters an order saying she abused her discretion, she goes ahead and she does it again. So you guys are going to see me win this appeal, and then I'm going to file a motion for costs, and the judge is going to deny that, and then the Court of Appeals is going to say, hey, you abused your discretion again. You need to stop. So we're going to go through this whole process, but this is the beginning of the biggest mistake that this judge makes in this case. There are going to be another couple of medium-sized mistakes that she makes, but we're going to focus on just this one for now because this is where we are in my docket series. I think with all of this being said, we're going to need to just go ahead and take a look at what the judge has filed. So here we have the judge's order denying a motion for supplementary proceeding in the aid of execution and granting attorney fees. First section here is that the court reviewed my motion for supplementary proceedings in the aid of execution, finds and orders as follows. Findings of fact. Wait a minute, what? You can't enter findings of fact without an evidentiary hearing. Okay, so they actually call her out on that. Okay, so guys, take notice of this. This judge is making findings of fact without having held an evidentiary hearing. So this is going to be mentioned by the Court of Appeals. I specifically mentioned the Court of Appeals saying that the judge's order didn't have any evidentiary support, and that's because she didn't hold a hearing. This is disturbing. Hopefully, she just doesn't know what she's doing. I mean, most of the time, I don't think the judges are evil. I just think they're incompetent. They just don't know how to do their jobs. Most likely, she just doesn't know that she can't do this, and she's just doing it anyway. Hopefully, she learns and stops, but for now, let's just go ahead and go into this. She says that I'm stating on my November 4th, 2014, the court ordered a wage assignment against my ex. That's true. Ordered my ex to pay $50 per month. This is for the arrearages only. I allege that my ex failed to make her $50 payment on the judgment was ordered. I state that I am entitled to examine my ex as a judgment debtor before a judge or domestic master. Consequently, I ask for an order requiring her to appear before the discovery commissioner to be examined. This is correct. This is consistent with the law. My ex objects in response, stating that she provided me with a check for $50 on December 23rd, which is late, and that the motion should be dismissed as what? Motions are not dismissed, they're denied. The verbiage matters when you're a judge. You need to know what you're talking about. So I don't know why she's saying that. The motion should be denied as the motion was filed to harass her. My ex, which requires evidentiary support. So this is what the Court of Appeals dings her on. They actually ding her on multiple things, but this is one of the big things they get her on. My ex alleges that she is currently on her judgment payments and will continue to remain current. This is a lie. What's so annoying is that the judge doesn't even care about this. So this is not true. Within even a month and a half, she's behind again. She just stops paying. My ex is not going to pay any of this money. As soon as this judge enters this order, my ex stops paying. My ex also requests attorney fees for having to file a response to the motion. I reply stating that I'm not properly served with a response. Additionally, I'm stating that as a judgment creditor, I'm entitled to examine her as a judgment debtor, which is true under the law. Moreover, I'm stating that my ex did not pay her $50 obligation until after I filed my motion. What? That's true. Yeah, okay, that's true. Basically, what I'm stating here, or I'm insinuating, is that had I not filed the motion, she just wouldn't have paid at all, which is true. I filed the motion, then she hires a lawyer, then the lawyer tells her to pay, because she didn't pay, the lawyer tells her to pay. You guys can, you've gone through the series, you know what's going on. I'm also objecting to my ex's request for attorney fees. Conclusions of law. A judgment creditor at any time after the judgment is entered is entitled to an order. Oh my God, so the judge even knows the law. She cites the law in her order and still gets it wrong. So this law here, NRS 21.270 subsection 1A, is absolutely true. This is what controls. The same law that the judge is citing is the same law that the judge fails to abide by. So here she says NRS 21.270 subsection 1A presupposes that there is an actual need for this information. Okay, so this here is the judge inventing her own interpretation. If you read the statute, it doesn't say this. Nowhere does it say this. This judge is just deciding, because she's invented this idea in her own head, that the law presupposes that there's an actual need for the information. The only basis that this argument would have worked is on the harassment section of the statute. But the only way she can get the harassment section to stick is to hold an evidentiary hearing, which she's not doing. So she can't have her cake and eat it too. If she wants to say that I am using the law correctly to harass my ex, she has to say that this law is being used correctly. However, we need to hold an evidentiary hearing to see if the only reason Alex is doing this is to harass her. She can't say that the law is being used incorrectly because it seems like I might be trying to harass her. That's not how it works. She has to pick one or the other. Most likely, she doesn't want to hold an evidentiary hearing because either she doesn't think that it's going to stick, which it won't, or she's lazy, which is possible. A lot of the judges are lazy and don't want to do it. Well, I should be more diplomatic here. It's not enough to say that they're lazy. It's possible that they have so much work that they just don't have time. And so it's not lazy in the sense that they're lazy people. It's lazy in the sense that they know that they're supposed to do this particular thing, but they want to break the rules because they feel like they don't have enough time to do what they're supposed to do. So it's not a laziness in the sense of a character flaw. It's in the sense of they know better, but they're not going to do what they're supposed to do because they just don't feel like they have the time to do it. I hope that makes more sense and is a little bit more fair to the judge. She's saying here that I did not even permit my ex a week after the order was entered. Okay, so this is another thing that really shows me that this judge is trying to CYA, cover her butt. So here, the judge is trying to say that I need to wait until after the order is entered to make her $50 payment. But she's not addressing the fact that this payment was due by the date of the actual hearing. She's not addressing that argument. So it's like she wants to be right, so she's trying to find whatever basis she can find to be right. And in this particular situation, she's going to say that it's going to start from when the order was entered. But nowhere has she said this. So if she was in the hearing and the judge said, Mr. Falcone, the $50 starts after the paper order is entered, then obviously I would have waited until a month after the paper order was entered. Spoiler alert, most likely my ex wouldn't have paid and I would have filed a motion and then she would have tried to pay late. But that's not what the judge said. The judge said she needs to pay $50. She needs to start paying her child support, blah, blah, blah. And now that I've done all this work and that my ex hired an attorney and that letters were sent, now the judge is going to decide, you know what, we need to pick a date and time that is very damaging to his position. And so the judge, it's annoying because it's like the judge almost takes the position of your ex's attorney. In my opinion, this is why the Court of Appeals is going to call her out for abusing her discretion. Because I don't even think they even address this. I don't even think the Court of Appeals even talks about this particular argument because it's so nonsensical. When we get to the actual order reversing and remanding, I'm going to hopefully remember to take a look through that order and see if they even discuss this particular portion of the judge's order. But I really don't think they do because they think it's inane. The next section here is that she says that the motion was unnecessary and that my ex was forced to respond. Of course, this is wrong. The next section here is that the request for attorney fees is granted pursuant to the statute. And this is 18.010 subsection 2B. And the Court of Appeals is going to go ahead and tell her that she's wrong about this as well. This entire order is completely wrong. My ex's attorney shall prepare and submit a Wilfong affidavit. So my ex is going to incur a bunch of attorney fees in preparing this order and this affidavit. And all that money is going to go to waste. So, the judge is trying to help my ex. I get that she's trying to white knight for her, but she's going to do a whole lot more damage to her because in the end, all this money is going to get reversed. She's going to have poured all of this attorney fees into trying to actually get these attorneys, all for it to be reversed as well. And then she's going to get dinged for costs. So all this work that this judge is doing to protect my ex is going to backfire spectacularly. And you guys are going to get to see it step by step through the process, how it happens. Okay, here we have the certificate of electronic service, which is indicating that this document was served both upon my ex's attorney and my attorney. And that's the end. So I have filed a motion to subject my ex to a debtor's exam. The judge has disposed of that motion by denying it. Going into the aftermath, I didn't file any documents, so I incurred $0 in costs. My ex's attorney didn't file anything, so she incurred $0 in costs. My attorney is helping me for free, so I incurred $0 in attorney fees. My ex's attorney would have probably spent only 15 minutes on this order because he still has to do a lot of work. He has to prepare the Brunzel affidavit or the Wilfong. I think it's Brunzel v. Wilfong affidavit. That affidavit is what discusses the amount of the attorney fee award. Not whether or not he's entitled to it, but it doesn't discuss, how much money he's entitled to. The affidavit is going to take him quite a bit of time to put together, but this particular order, just reviewing it, not really. I think 15 minutes is reasonable. At the rate of $250 an hour, that's going to come to $62.50 in attorney fees for my ex. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.